Well, good morning or good afternoon, everyone. Welcome to this webinar. We are very pleased to be working with Sheehan, Phinney, Bass & Green on a very current topic that is of concern to a lot of businesses in New Hampshire. My name is Tim Sink. I am president of the Greater Concord Chamber of Commerce. As you can see from the screen, we always welcome new members to the chamber, so we'd be delighted to talk to you about benefits of membership or actually renew some of your interest. For those of you who have been members for a while but may not be as familiar as you used to be, we have a means for you to become more acquainted with chamber member benefits, and we'd be happy to do that. So if we can move on to the next screen, I just wanted to spend a moment or two talking about some upcoming events at the chamber. And so we have a listing in front of you right now, but we are hosting a virtual meeting. It is a career pathways meeting, and this is a means by which businesses in New Hampshire can connect with local schools and interest students in career pathways into their various careers. It's a workforce initiative, and we would love to have you participate in this. If you had any interest in sort of creating a pathway for students in high schools to learn more about your businesses and how they may look at a career pathway. I wanted to mention that we have a luncheon coming up on Thursday, January 13th. It's 11:30 a.m. to 1 p.m. at the Holiday Inn. And this is our legislative outlook. We've got some terrific media panelists that will be joining us from WMUR, from Union Leader, from the Lakes region, and this event will be moderated by David Juvet, who is Vice President of the Business and Industry Association. So really cool outlook for legislation for 2022. Also want to draw your attention to our Young Professional Network, Concord Young Professional Network, or SIPN as we call it. They'll be doing a social networking gathering on the 19th at Litherman's here in Concord at 5:30. Very easy to get involved with that. Just let us know that you're interested in attending, and there's no charge to attend, and we'll make sure you get registered and we have a name badge for you. And then finally, as I had mentioned earlier, if you're interested in getting more engaged with the chamber or a refresher on member benefits, we are hosting an orientation. We call it Meet Your Chamber. It is a lunch meeting at the chamber on Wednesday, January 26th. There's no charge to attend. Just let us know we're coming so we can make sure we have a sandwich for you here. And we'll just walk you through what we have here at the chamber, different committees, different opportunities for networking, member benefits of all kinds. So we would welcome your participation. All these events are up on our website at concordnhchamber.com. On the landing page, you just click on the link and you get yourself registered, and off we go. So that is what I had to do for getting started. It's my pleasure to introduce our speaker today. Brian Bouchard from Sheehan, Phinney, Bass & Green is a seasoned litigator and counselor, and he works out of the Portsmouth office, where he works in the firm's litigation and employment law departments. In the labor and employment field, particularly, Brian counsels and represents companies through all manner of complexities, including claims involving discrimination, retaliation, and wage and hour violations, questions involving employee management, executive contracts, employee mobility, and legal compliance. Brian's clients range from VC-backed tech companies in Boston to small rum distilleries out on the seacoast, and just about everything in between. He has published and lectured on legal topics throughout New England, and is really well positioned to make this presentation. So Brian, thank you so much for doing this. Thank you to Sheehan, Phinney, Bass & Green for putting this together for us.
Thank you so much for having me, Tim. I greatly appreciate it.
One last thing I forgot to mention, there is opportunity for Q&A, and I see we already have a question. So at the bottom of your screen, you see the Q&A button. Just tap on that and you can type your questions in, and at the end of the presentation, we'll get to those. Sorry for the interruption, Brian.
No, not a problem at all. Thank you for having me, and thank you for the introduction, Tim. It's good to be with the Concord Chamber this morning. Let me take a moment and share my screen here, because I do have a PowerPoint presentation for you all, and hopefully I'll do this right. Okay, hopefully everybody can see my screen right now, and we'll be good to go. So as Tim mentioned, I'm an attorney at Sheehan, Phinney, Bass & Green. I'm personally based in Portsmouth, New Hampshire. However, we do have an office in Concord. We have a very lovely office in Concord that's been there since I've been with the firm and for much longer than that. In normal times, I would say stop by and visit us, but I don't think that's going to happen really anytime soon. But hopefully by the summer, we'll be able to get together in person in one capacity or the other. So today, I want to really jump into this. We are going to be talking about updates to OSHA's ETS. That is the Emergency Temporary Standard promulgated by OSHA in November that was temporarily held in abeyance by the courts. But depending what happens at the Supreme Court on January 7th, could be back in full force and effect. A brief disclaimer, while I am an attorney, while Sheehan Phinney employs many of the best attorneys in New Hampshire, this program is for educational purposes only, and it is not a substitute for legal advice. Many of these issues are complicated, they are nuanced, and they require a case-by-case analysis. So if you do have questions, particularly questions related to your business, please contact Qualified Labor and Employment Counsel. If you have a question, please put them in the Q&A. And I will do my best to answer them at the end of the presentation. I might not be able to see if the Q&A is being populated as I do the presentation. I do see that there is one question in there already, and the answer is that the CMS and OSHA ETS are not related. You're either governed by one or you're governed by the other. However, it's not really clear how that may play out because the CMS is being held in abeyance as well and could be struck down depending on what state you're in. So I think, New Hampshire and a bunch of other states, I think 11 other states, including North Dakota and South Dakota, filed lawsuits seeking to enjoin the CMS, and those preliminary injunctions were granted. So the CMS is not enforceable in New Hampshire. It may mean, therefore, that if you are an employer with 100 or more employees, that OSHA's ETS does apply to you. However, it's not really clear. So let's talk about the ETS litigation. The ETS was promulgated on November 5th of last year, and it was immediately met by lawsuits. There was a lawsuit filed in every circuit court in the country. The Fifth Circuit was sort of the first one to rule on it, first in time, first in right. And the Fifth Circuit issued a permanent injunction with respect to the ETS. The Fifth Circuit said that the ETS grossly exceeded OSHA's authority and that it posed an undue financial burden on companies, and that it was also potentially violative of the Commerce Clause of the Constitution. What happened from there, because every circuit court was dealing with a lawsuit concerning the ETS, was there was a multi-district litigation lottery where quite literally a clerk of the court picks out a ping pong ball with whatever circuit court is going to take up the issue and have final circuit court review of that issue. The Sixth Circuit was chosen in the beginning of December, and towards the end of December, the Sixth Circuit issued a split 2-1 decision that reversed, it says the Sixth Circuit, but reversed the Fifth Circuit and lifted the stay. The Sixth Circuit found that OSHA had demonstrated the pervasive danger that COVID imposes on the workplace to unvaccinated workers, and therefore there was a demonstrated need for the ETS. Now, everything is going to be reviewed by the Supreme Court. There is an accelerated argument period. Oral arguments are going to occur on January 7th of this year, so in a couple of days here. Now, many people have asked me what I think the Supreme Court is going to do. I'll be quite candid with you. I have no idea, not the foggiest idea. There is precedent to suggest that the Supreme Court would uphold the ETS and the vaccine mandate. And there's a couple cases indicative of that result. First is Jacobson v. Massachusetts, which is a case from 1905. In which Massachusetts imposed a statewide vaccine mandate to combat smallpox. A Lutheran minister refused based on religious grounds, was eventually jailed, or excuse me, was fined, then jailed, and he petitioned to say that Massachusetts's vaccine mandate was unconstitutional. The Supreme Court disagreed in the case of Jacobson and upheld the vaccine mandate. The case of Jacobson has been cited as recently as 2016 as good and valid precedent from the United States Supreme Court. So there is reason to believe that the Supreme Court may look to that case when deciding this issue. Recently and last year, there were 4 cases in which the Supreme Court declined to grant certiorari or left a order of the circuit court in place that did not enjoin a vaccine mandate. So John Doe's 123 versus Mills comes from the state of Maine, and that applies to healthcare workers. It was a healthcare vaccine mandate. And quite interestingly, there was no exception for religious accommodations. Even someone, if they're in the healthcare field, if they had a religious accommodation or religious belief saying that they couldn't be vaccinated, no exception for that. The First Circuit allowed that law to take effect, and the Supreme Court didn't take it up. Dr. A. V. Hochul comes from New York. That's another healthcare vaccine mandate. Clayson versus the trustees of Indiana University comes from the state of Indiana, where the university system of that state imposed a vaccine mandate for individuals to attend university in that state. The circuit court allowed the mandate to take effect and said that, look, individuals don't have a constitutional right to attend university at Indiana. They can go elsewhere. Therefore, the vaccine mandate is valid. The Supreme Court declined to take up the issue. And Valdez versus Grisham comes from New Mexico, and that too is a healthcare mandate where the Supreme Court allowed the mandate to take effect without having review by the Supreme Court first. So there is at least some precedent to say that the Supreme Court would allow OSHA's ETS mandate to take effect and would not enjoin it. That said, the cases that I've just discussed deal with state rights and deal with state mandates. So far, as far as I'm aware, there hasn't been anything dealing with the authority of OSHA to implement a vaccine mandate like the type we're seeing. And so we do have a conservative block in the Supreme Court, a 6-3 conservative block. It's quite possible that the Supreme Court may say, yes, those other issues concern states' rights, and those are issues for the state. However, what we're dealing with now is the authority of a executive agency in the federal government to issue this type of mandate, and we're going to have to see what the Supreme Court says in that regard. Now, because of the initial Fifth Circuit stay, compliance deadlines have changed for the ETS. Originally, there was a December 5th compliance for all obligations under the ETS except for testing. And then by January 4th, which is today, compliance with all ETS obligations, including testing, would take effect. That has changed. Now you have 2 different phases. So OSHA will not issue citations for non-compliance with any requirement of the ETS before January 10th of 2022. Now, I personally don't think that we're going to have an order from the Supreme Court by then. So therefore, I think it behooves every covered employer to make sure that they are in compliance with the ETS by January 10th to avoid OSHA fines, which can be significant, certainly over 5 figures. Then phase 2, OSHA has said that fines for testing for non-compliance, will commence February 10th of 2022. However, there is one caveat to that. OSHA isn't going to fine an employer for not complying with the testing requirement, but only so long as the employer is making good faith efforts to comply. So don't think that you have until February 10th of 2022 to institute testing requirements. Those testing requirements should be instituted immediately, certainly by January 10th of 2022, if the Supreme Court either allows the ETS to take effect or doesn't issue an order by then. Because OSHA still can fine you as an employer if you are not making good faith efforts to implement the testing requirement. Now, let's talk about what the ETS is, what it isn't, and what it requires for employers. So the ETS requires all employers with 100 and more employees to promulgate a policy either requiring testing or requiring employees to be vaccinated. And we're going to talk a little bit more about what that policy requires. That has to be implemented by the employer. For now, though, let's just focus on whether or not a company is going to be covered by the ETS. So coverage applies to companies with 100 employees or more. pretty basic here. There's no consideration for indoor work, outdoor work, remote work. Part-time employees count as one employee, temporary employees count as one employee, anyone on the company payroll counts as one employee. Okay, so it's pretty easy. Look at your payroll as of November 5th, 2021, which we'll talk about. If you have 100 or more employees, you are a covered entity. You can expect that there's going to be some joint employer issues, but this is meant to have very broad coverage, okay? So you need to look at coverage at the corporate level, not at the individual workplace level. So any corporation that has 100 or more employees, it's covered. I want to talk briefly as well as to what an ETS is. An ETS is called an emergency temporary standard, and it is in OSHA's enabling statute, and it allows OSHA to issue what is in effect a regulation, a binding legal regulation, without having to go through notice and comment first. OSHA is allowed to do that so long as there is a grave danger in the workplace. The ETS lasts for only 6 months, and they are very, very rare. I think actually before this year, there was only one ETS that OSHA has issued in its history, and that was in the 1980s, and that was to deal with asbestos in the workplace, and that was eventually struck down by, I think, a New York court. Simultaneously, however, OSHA has also promulgated regulations that look identical to the ETS to go through the notice and comment period, because what's going to happen is once the ETS expires at the end of 6 months, it is expired unless it is replaced by a permanent regulation. So the notice and comment period is happening right now. I think the deadline for comments is January 19th of this year. So keep that in mind if you're an employer who does want to make a comment to the notice and comment period. Now, let's talk about entity coverage a little bit more. We know that it's 100 employees or more. The measuring date for this is November 5th, 2021. That has not changed, okay? Even though the ETS has been held in abeyance, the measuring date is still November 5th, 2021. So if you had 100 employees as of that day, you're covered. If you did not have 100 employees as of that day, but later on, and still within the 6-month period of the ETS, you reach a number of 100 employees or greater, then coverage applies to you. If you had 100 employees at any point during the ETS, but later you have a reduction in force of some type, and you drop below the 100 employee threshold, the ETS still applies to you for the remainder of the ETS, again, 6 months. So you can see in this little graph chart that I made, employer one, okay, as of November 5th, has more than 100 employees. It is going to be bound by the ETS. Employer two, as you might be able to see in red, is just below the 100 employee threshold at 99. Sometime in January, it crosses over that threshold, and as soon as that cross happens, it is governed by the ETS. Employer three is the more interesting one. Maybe it could be a ski area. As of November 5th, it only has 40 employees. Ski areas generally build up for the wintertime. Goes up to around 150 employees as of January. And then as of March, goes back down to 40 employees, which the ski season probably won't end there. And maybe it's a little aspirational for winter to end in March. But even though the employer, as of March, only has 40 employees, it is still bound by the ETS. As far as I'm aware, there is no leeway or runway given to employees who, during the period of the ETS, reach the required threshold. In other words, as soon as you reach 100 employees, you are obligated to comply with the ETS. There is no period of leeway in which you reach 100 employees and then you have 2 weeks or 3 weeks to comply, for example. My understanding is that it is immediate compliance. So let's talk about what is required for an employer who is covered by the ETS. Well, first thing is the employer has to decide on the type of policy that's going to issue. And depending on the type of policy that the employer issues, there's going to be additional obligations as to testing and face coverings. You need to determine the vaccine status of the workforce and collect immunization records. The employer has to provide COVID information to its employees, and covered employers have to go through a quarantining protocol for anyone who tests positive for COVID. And there's also a reporting obligation for employers who are covered by the ETS as well. So let's talk about the vaccine policy first. OSHA gives employers two options, as I mentioned. The first option is to require every employee to be vaccinated. Plain and simple. Mandatory vaccination for everyone unless the employee has a medical accommodation or has a religious accommodation that applies to them. That's option one. Option two is to generally require a vaccine mandate, but if any individual, for any reason, decides that they do not want to vaccinate, that individual would then have to go through weekly testing. And those tests, as we'll discuss, have to be submitted to the employer every week and then maintained in a record for the duration of the ETS. Now, employers are required to have this policy in writing. It has to be disseminated to all employees. Nothing is going to be submitted to OSHA, okay? Now, I've gotten this question a few times. Can we mix and match the policies? The answer is yes, you can mix and match them. What you can do is, as an employer, you can say, look, all customer-facing employees are required to be vaccinated unless they have a medical or religious reason not to be vaccinated. Everyone else gets the option of either being vaccinated or going through the testing period, okay? Keep in mind that your policy here has to cover, the requirement for vaccination, the applicable exclusions, i.e. what accommodations may apply, information on determining vaccine status. It also has to include the policy for paid time for vaccination and sick leave for recovery. It has to include what's required for notification of a positive test result. It has to include what's going to happen for disciplinary consequences for noncompliance. It has to include the deadlines for compliance, and it has to include who the enforcement personnel is going to be for the policy. And obviously, if your workforce is not 100% vaccinated, your policy also has to include testing requirements and requirements for facial coverings, which brings us to, I think, the question that everybody is interested in, and that is testing. So employees who decline to vaccinate for any reason, and that could be because of a medical reason, that could be because of religious reason, or that could just be because the employee does not want to vaccinate, provided, however, that the employer selects a policy that allows for that option, must test weekly. And test results have to be submitted weekly to the employer, and they have to be saved. Now, these records are considered medical records under the ADA, and so they have to be stored in a secure location, and they can only be accessed by individuals who should have access to those testing records. Okay, so you as the employer need to find a way to build out security systems that enable you to take in this confidential information and maintain the confidence of that information for the duration of the ETS. And it will, in fact, the confidence applies in perpetuity, but you only have to maintain the records for the duration of the ETS. Now, employers are not required under the ETS to pay for the weekly test. However, we live in New Hampshire. And so New Hampshire has promulgated a regulation through the Department of Labor that says no employer shall require an employee or applicant for employment to pay for the cost of a medical examination. That includes a COVID test. However, this shall not include examination, permits, or licenses required by federal law. Now, many of you may be thinking, well, the ETS is required by federal law. It is promulgated by OSHA. Therefore, we as the employer do not have to pay for the test. Not so fast. While the New Hampshire Department of Labor has not issued any official guidance, unofficially, I have heard that the position of the New Hampshire Department of Labor is that the testing is actually being required by the employer and is not being required by federal law. And here's how that works. The ETS gives every employer the option of either requiring everybody to vaccinate or allowing people to either vaccinate or test. If the employer selects the second option of allowing testing, then the test that is required under the ETS is not technically required by federal law because the employer has the option of requiring everybody to vaccinate. Of course, if the employer does select the option of having everybody vaccinate and someone has an accommodation and then they need to be tested, Well, of course, requiring that employee to pay for the testing as part of an accommodation would be antithetical to the ADA and Title VII. So, if you are testing as a method of accommodating an employee, the employer would have to pay for that test anyway. There are free testing sites throughout New Hampshire. You can require employees to go to those free testing sites. I would caution, however, that free testing sites may take longer, and it may take longer for the employee to get to those free testing sites. Right now, the USDOL has not issued any clear guidance as to whether testing is compensable or not. My view of the regulations for the FLSA is that testing more likely than not is going to be considered compensable time because it is something that is required by the employer. There are certainly good arguments that exist anyway that suggest that testing is going to be compensable. So far, there hasn't been clear guidance from the USDOL that I've seen, however. So how often are you required to test? Well, employees are required to test once every 7 days. If you are a remote worker, you are not required to test. However, the rule is that if you are going to go into the office, you are required to test before you go into the office. And that if you are in an office setting or driving in a car with another employee or in any way connecting with other employees for the benefit of the company once every 7 days or once a week, that employee, if they are not vaccinated, is required to test. So just to be clear here, remote workers are not required to test, but if they are going to go into the office, then they have to submit a negative test within the 7 days before reporting to work. If an employee does test positive for COVID, that employee is not required to test for 90 days. The reason being here is that there's more likelihood of a false positive within the 90 days after you test positive for COVID. So an employee is granted a 90-day exemption from testing if they do test positive. What tests are accepted? Well, here they are. The test has to be approved or authorized by the FDA, and it has to detect the COVID-19 virus. That seems like a given. The test has to be administered according to the authorized instructions, obviously. And this is a question that I've seen circulating around LaborNet for quite a while now, is that the test cannot be self-administered or self-read unless it is observed by the employer or an authorized telehealth proctor. So many of the questions I've received is, can we use over-the-counter tests? The answer is yes, you can use over-the-counter tests so long as they are FDA approved, but you as the employer have to observe the actual test being taken, or that has to be observed by an authorized telehealth worker. Some other questions. Are photographs of the test results appropriate? After the fact photographs? No, they are not appropriate. Are after the fact videos of the testing process appropriate? The answer is no, they are not appropriate. Can the employer do some type of remote viewing for the test where the employee on a Zoom call like this takes the test, sits and waits for the result? Yes, that is appropriate because that is happening in real time. But anything after the fact is inappropriate. Can employers be cited for lack of testing supplies? In other words, an employee is trying to go and get tested, but right now with the Omicron surge, we're experiencing a severe lack in testing. And the answer, according to OSHA, is yes, employers can be cited if an employee does not test. However, OSHA will take good faith efforts into consideration if an employee is unable to get a test due to lack of testing supplies. But that still means, though, that if an employee is unable to get a test, they can't report to work until they test negative. Another question I've seen a lot is, how do we document tests that are over the counter? How do we document those results? Because we're required under the ETS to document and maintain these results for the duration of the ETS. A couple options. One is you can actually take a photograph of the test result. Second is you can record the testing process if that is happening over Zoom, or the person who is in charge of the ETS policy can simply write a notation that they're going to keep in the file saying that I observed Susie Smith taking the test on January 2nd, 2022, and she tested negative. That is sufficient as well. Face coverings. Non-vaccinated individuals, for any reason, must wear face coverings when indoors or when occupying vehicles with another employee for work purposes. The exceptions here are when the employee is alone in a room. Now, OSHA actually means a room here. So 4 walls, a ceiling, and a floor, and a door that closes. A cubicle is not sufficient. The other exception is when a face covering creates a hazard, any type of machining work, for instance. The employee is wearing a respirator and therefore cannot simultaneously wear a face mask, or the employee is eating or drinking. Even if the employee is at their cubicle, they're not required to wear a face mask during the process of eating and drinking. Unlike the federal contractor mandate, there is no requirement for social distancing. Okay, that's not a part of the ETS. There are also no rules with respect to customers or vendors wearing face masks in your places of employment. However, under the ETS, you as the business cannot prohibit a customer from wearing a face mask or covering, but there's no requirement that you require anyone visiting to don such a face mask. Keep in mind as well that it is the responsibility of the employer to ensure that face masks are properly worn and that every face mask meets the definition of face covering under the ETS, and that is carefully defined under the ETS as well. Employers are also obligated to determine the vaccination status of every employee. Vaccination status means someone who is fully vaccinated. So 2 shots of Moderna, 2 shots of Pfizer, 1 shot of J&J. No boosters are applicable here, okay? So regardless of the policy you select, you have to determine whether everyone in your workforce is either fully vaccinated, partially vaccinated, or non-vaccinated. And you have to maintain a roster of the vaccination status and maintain the acceptable proof of immunization from every individual who claims that they are vaccinated. These, again, are going to be confidential medical records under the ADA. So the roster is confidential, as well as the immunization records. Those are confidential as well. Be warned, however, that when you start collecting vaccine cards, you could find yourself in an awkward situation if your workforce was one that implemented social distancing and mask requirements over the summer and last fall for those individuals who were not vaccinated, but everybody else in your workforce was going about business as normal if they were vaccinated, and you did so on an honor system. You could find that some of the employees who said that they were vaccinated may not have been vaccinated, and you're going to have to deal with that. It happens a lot, particularly if you're the owner of the Green Bay Packers. Okay, so importantly, OSHA can require that employers provide COVID-19 immunization records and testing records, and they have to be produced by the next business day. So that is a very tight turnaround if you have 100 or more employees. So imagine OSHA sends you a letter that says, send us all the vaccination records and testing records for when all 120 of your employees, for example, and those are due to us by close of business the following day. Can you do it? If you cannot do it, or if the answer to my question is no, you need to set up some processes right now to ensure that you are able to meet that compliance deadline with alacrity. Acceptable proof of vaccination. Here they are. We're going to distribute these slides afterwards. So in the interest of time, I'm not going to go through every individual one. I will note, however, that if an employee is unable to provide the immunization records as identified in this slide, there is another option for them where they're able to sign an affidavit. The affidavit has to attest to their vaccine status. It has to say that they have lost their information. And they have to acknowledge as part of the affidavit that they could be subject to criminal penalties for dissembling about their vaccine status. And the affidavit option is really only available if the employee is unable to produce a vaccine card that is acceptable under the ETS, which again is on the slide. Covered employers must inform each employee in a language and at a literacy level that they can understand about the requirements of the ETS. That is going to include whether the company's policy has adopted a mandatory vaccination or an optional vaccination status. You are required to provide COVID-19 vaccine efficacy, safety, and benefits. Don't worry, that is a form that is available on the CDC website, but it does need to be disseminated to all employees as part of the employer's policy. You're also required to inform employees about 11C retaliation, which means that employees cannot be retaliated against for reporting workplace injuries or for reporting what they deem to be workplace violations or violations or events that they, in their belief, seem to be violative of any OSHA law. So you have to inform employees about their rights for retaliation. You also have to inform employees that there are criminal penalties for providing false statements, documents, and information. So that can include any employee who provides a false vaccine card or any employee who provides false testing information. There are also reporting obligations, and this is really the only time where anything's going to be reported into OSHA as part of the ETS. So you have to report all COVID-19 related fatalities within 8 hours after learning of them. A COVID-19 related fatality is one that involves complications involving COVID-19. So if someone, God forbid, is in a car accident and they have COVID-19, that does not qualify. The issue has to be COVID-19 related, or the event has to be COVID-19 related. Employers are also required to report COVID-19 related hospitalizations within 24 hours of learning of them as well. Again, all reports are made to OSHA. Quarantining. Covered employers must require employees, regardless of vaccination status, to quarantine if they test positive, and every employer is required to mandate that their employees report all positive tests of COVID-19 to them immediately. The employee stays in quarantine until they test negative. They complete the CDC isolation guidance, which recently changed from 10 days to 5 days. Although I read in the Times yesterday that while it's likely to stay at 5 days, it's more likely than not that the CDC is going to implement some type of testing requirement as part of the 5 days, meaning that an employee can get out of the 5 days quarantining requirement if they produce a negative test. If they are unable to produce a negative test, the quarantining may stay up to 10 days. So expect some changes there and keep an eye out for it. An employee can also come back to work if they receive clearance from a licensed physician. So compensable time, this is another issue that we've been dealing with a lot at Sheehan. And that is the time that employees get to become vaccinated. Every employee gets 4 hours per vaccine dose paid for by the company. If an employee chooses to go to a vaccine clinic on the weekend, for example, that time doesn't have to be paid. But every employee must receive and must be notified of their right to receive up to 4 hours of time to go and get vaccinated, and that is per dose. That has to be provided at the employee's regular rate of pay, and you cannot require that the employee use some type of personal time in lieu of them getting paid. The reason for this requirement is OSHA doesn't want people not to get vaccinated because they are concerned about losing potential PTO for the time it takes to get vaccinated. On the side of recovery, employers are required to provide a reasonable time for the employee to recover from any side effects from the vaccine. While there is no set duration established by OSHA, OSHA has said that a reasonable time to recover from the side effects of a vaccine is likely 2 days. So there's flux there. You can set caps, but certainly the cap cannot be less than 2 days. Employers can require that employees use their sick time for recovery, but nothing else. So if you are a company that divides PTO into vacation time, personal time, and sick time, you can require the employee to use the sick time to recover from the vaccine, but they can't use the personal time and they can't use the vacation time. If your paid time off policy is simply one bucket, then that can be used for recovery of the vaccine as well. But certainly there has to be some time provided. If the employee is out of sick time or out of PTO entirely, they're still entitled to reasonable paid sick leave to recover from the side effects of the vaccine. Now, this goes to one of the questions that we got earlier at the beginning of the presentation, is that the ETS applies only to one of the federal schemes, the federal schemes being those that have come out of the Path Out of the Pandemic plan announced by President Biden, I think in October, maybe September. However, it's a little unclear what's going to happen here. The CMS has been enjoined in New Hampshire and is not effective in New Hampshire. So I can see an argument existing that if the CMS doesn't apply in New Hampshire and the employer is otherwise covered by OSHA's ETS, then the OSHA ETS applies. There may be some details in the regulation there. I could also see an argument here regarding the federal contractor rule, which is also going to be taken up by the Supreme Court on January 7th. If that does not apply and is void ab initio, then I can also see an argument saying that OSHA's ETS would apply instead. I don't think OSHA has made any announcement on that, and I certainly haven't seen anything in the regulation regarding that. The healthcare ETS from June sunsetted on December of last year, December 21st of last year. It has not been replaced. There could be a final rule that is akin to it coming in April, but we're going to have to see. Finally, to round out the presentation here, I did want to talk for a few minutes before we move to the Q&A on religious accommodations, because they're becoming more and more prevalent. I'm sure many of you know that the ADA requires employers to accommodate individuals with a disability, but there is also an accommodation requirement under Title VII, and that is to accommodate someone's sincerely held religious beliefs, observances, or practices. The burden, like with all accommodation requests, is on the employee to request the accommodation. Again, there's no magic language here, however. What you need to look at is, okay, is reasonable information provided to the employee to suggest that the employer that the employee needs an accommodation of some type. So if the employee comes to you and says, my beliefs conflict with the vaccination requirement, that likely is enough to suggest to you as the employer that the employee is requesting a vaccination. Oops, sorry, back up a little bit. Notice that the undue hardship test for religious accommodations is materially different than the test under the ADA. Hardship under the ADA must cause significant difficulty and expense to the employer. Okay, so an employer is required to grant an accommodation unless the accommodation requested is going to, be significantly difficult operationally or expensive for the employer. Title VII is different, and it is a far more generous standard to the employer. The undue hardship under Title VII is something more than a de minimis cost. Okay, so if the accommodation requested by the employee is more than a de minimis cost to the employer, the accommodation does not have to be granted. Depending on the company's workforce, the mode of work, the type of industry, it's possible that no employee would qualify for a religious accommodation. That has to be handled on a case-by-case basis, however, and you need to take a look at really what the company is doing and who the company is serving. Okay, the burden is on the business to prove an undue hardship. So you want to be careful in just saying that, any request for an accommodation is an undue hardship, because that may not be the case. These things need to be well documented. Probably in the last, 8 years, I have had one religious accommodation case come across my desk, and in the past 4 months, I have been flooded with them. I was on a panel towards the end of last year with someone from the EEOC, and she said during the panel conversation that claims at the EEOC for religious accommodations are up 300%. And really the only reason for that is people seemingly do not want to be vaccinated. Some of that may be for religious reasons, some of that may be for secular reasons. But either way, the EEOC is being inundated right now with cases for religious accommodation. I imagine the same is true for the New Hampshire Commission for Human Rights. What does religion mean under Title VII? Well, it includes traditional religions, Christianity, Judaism, Islam, Hinduism, Buddhism, but it also includes religions that are non-traditional, that are uncommon, are not part of a formal church, or held by only, or beliefs that are held by only a small number of people. Religious practices can be protected even if they deviate from traditional religious beliefs. So keep that in mind as well. Social, political, and economic philosophies or personal preferences are not religious beliefs, okay? There has to be, generally speaking, some type of deity involved or faith-based system involved, although atheism is a religious belief, but I can't imagine someone saying that they can't be vaccinated because of their atheist beliefs. That wouldn't really hold water. The religious belief by the employee needs to be expressed by the employee, and the employer is entitled to ask the employee what their religious belief is, and if the religious belief is non-traditional, you can ask the employee for the basis for that religious belief, where it comes from, and what the religious belief means. The religious belief, in order to be subject to an accommodation, has to be sincerely held by the employee. Most of the time, and the EEOC just issued guidance on this, there is no reason to question whether a particular practice or religious belief is sincerely held. However, in cases of bona fide doubt, the employer is allowed to make objective, limited inquiries into the sincerity of an employee's religious beliefs. So how do you know whether you have bona fide doubt? Well, you can look at these examples. Or look at these guideposts. Whether the employee has behaved in a manner markedly inconsistent with the professed belief. So if a person is saying that they are Christian, Jewish, or that they're Muslim, and that they're unable to get a vaccine because of their religious belief, but that same person is also covered with tattoos, for example, well, that's going to be something that's different from the teachings of those faiths. And so you may be able to question the sincerity of the employee's religious belief there. Another factor to consider is whether the accommodation sought is particularly desirable benefit that is likely to be sought for secular reasons. I think with any case of a vaccine, that is going to apply here. On both sides of the aisle, there is significant vaccine hesitation and there is significant vaccine opposition. So I think in almost every request for an accommodation, this box is going to be checked. Although you don't have to meet all of these requirements, you just have to really meet one of them in order to make a limited inquiry into the sincerity of an employee's religious beliefs. You got to look at whether the timing of the request renders it suspect. Again, the mandate is just coming out. Has the employee requested religious accommodations previously? That could be suspect. And whether the employee otherwise has, whether the employer otherwise has reason to believe the accommodation is not sought for religious reasons. What you can do there is you can check the employer's, the employee's Facebook, social media. Use caution. You can't ask an employee for their password or ask the employee to friend you on social media. But if it's open to the public and they're saying something against the vaccine that has nothing to do with their professed religious beliefs, that may be reason to make a limited inquiry into the employee's sincerity of their religious beliefs. I would caution here that trying to determine whether or not an employee's religious beliefs are sincerely held is a very difficult and onerous task to do, because at the end of the day, you're going to have to speculate to some extent. And these types of questions have to be handled on a case-by-case basis. And it simply could be the case that, depending on the type of organization, some organizations may do better finding that no vaccination constitutes an undue, that non-vaccination constitutes an undue hardship for the workplace, and that therefore it cannot be accommodated. Remember too that religious beliefs may evolve over time, which makes this all the more tricky. Just because an employee is otherwise vaccinated in every other respect, it does not mean that their belief system hasn't shifted recently. And as an employer, you are required to accommodate that shift in belief. What are the best practices here? Consider each request for an accommodation on a case-by-case basis. Carefully document requests for accommodation and supporting reasons. Carefully document reasons for the decision issued by the company. and have an accommodation decision be made by the same person or the same group of people whose authority is final on the matter. Okay. You don't want to have exceptions being made to those people who are close to the president of the company or the CEO, for example. Don't forget, this is fundamentally an interactive process, just like under the ADA. I recommend that all employers develop a form that employees can use and they can fill out, stating their professed beliefs, stating why they are unable to be vaccinated because of their professed beliefs. And then that form can be used to guide the interactive process. The form is also going to include the type of accommodation being requested by the employee. It could just be working from home, and that resolves a lot of issues. I personally would use the EEOC's form as a guidance. The EEOC published its own form, and it was intended to be used as guidance for employers. So I would take a look at that. It's available online, and develop your own form as an employer. All right, last couple slides here. What to do now? First, you need to determine whether the ETS does apply to you or not. Are you a covered employer? Do you have 100 or more employees? If you don't, here's what you need to do. You need to establish whether or not you want vaccine mandates as a matter of policy in the company. You may decide yes, you may decide no. If the ETS doesn't apply to you and none of the other regulations don't apply to you, then that's really a question that is left to the company to decide. Every company, in my opinion, needs to review OSHA's protecting workers guidance and the general duty compliance with respect to that guidance. OSHA has a general duty clause that requires all employers to provide a safe place for employees to work. My belief is that that requirement requires at a minimum that every business, every employer go through OSHA's protecting workers guidance and make reasoned and informed decisions as to what aspects of that guidance the employer is going to adopt and what aspects of that guidance the employer is not going to adopt. If you are covered by the ETS, then my recommendation is that you begin preparing for the ETS as if it will take effect immediately. Citations will begin next week, January 10th. I don't know what the Supreme Court is going to do. I don't think anybody knows what the Supreme Court is going to do. And I'd be very surprised if the Supreme Court gave us a decision by the 10th. So that means developing and disseminating a vaccine policy, choosing whether you want to do mandatory vaccines or the option for vaccine. Create your vaccination roster, build out security networks to ensure that confidential medical records are going to remain confidential. Establishing testing processes, establish processes for managing accommodations, because if you do implement a vaccine mandate, you likely will be flooded with them. With that, we're going to wrap up the presentation. We're going to move on to some questions I see in the Q&A. Of course, if anybody has a question about this, this is my contact information, my phone number and my email. If you have questions, please reach out to me. I'll answer them when I can or where I can. And otherwise, if you do have questions about this complicated body of law, please make sure that you do talk to qualified labor and employment counsel and don't go about this alone. The regulations are nuanced, they're complex, they can be contradictory sometimes. And in some cases, there simply is no published guidance yet, like with respect to the testing requirement. So let me go to the Q&A, and we have a few minutes left for questions. All right, so the first question from Peter is, how temporary is the ETS? Well, the ETS only lasts for 6 months. So it is temporary in that respect. At the same time, however, OSHA has promulgated, it has begun the notice and comment period to make the ETS requirement a permanent regulation. Comments are due at the end of this month. And after that, we can expect OSHA to issue a formal regulation probably later in the spring. Has NHDOL determined if employers will have to pay for testing? Not officially, as I said during my presentation. I think the unofficial guidance here is that because employers are given the option of either requiring all employees to vaccinate, or giving employees the option, the choice that is given to employers means that the testing requirement is not a federal regulation, but as a policy of the workforce. And if it's a policy of the workforce, then companies are required to pay for it. Okay, Stacy, do you have a list of states that also require employers to pay for medical tests? I do not have a list of states off the top of my head. I can probably get one for you quickly if you want to send me an email. Catherine, what about if the employee testing has personal access to a medical technologist to oversee the test? So long as the medical technologist is an authorized healthcare teleworker, which is the exact language I think used by the ETS, that is fine. Catherine's question here, I think, relates to an employee taking an over-the-counter test at home, for example, to prove that they are negative with the virus, and how that test has to be observed. It can be either observed by the company, or it can be reserved by an authorized telehealth care worker. Maybe a medical technologist qualifies. The regulations don't really say. I'd have to know more about what a medical technologist is. Stacy, is the issue of PTO for this issue of PTO for testing is huge. We will have regulatory guidance at any point. The only guidance I know of from OSHA is that the reasonable paid leave is 2 days is reasonable. So that came up in a question as to whether employers can set caps as to the paid PTO. And OSHA said you can set a cap, but we would expect that the cap is not going to be fewer than 2 days, because we view 2 days to be reasonable to recover from the side effects of the vaccine. That being said, just because 2 days is deemed reasonable by OSHA doesn't mean that every employee is entitled to 2 days leave after they get vaccinated. Okay, it's only available if the employee needs that time to recover for the side effects of the vaccine. So you are able to ask the employee at least some inquiries as to whether or not that time is actually necessary for them. Question from Amy. Does the employer have to make the copies and physically see the vaccination cards, or can we accept copies sent by the employees to the employer? You can accept copies, but you do have to maintain a copy of the vaccination card. Keep in mind that with the policy you're going to disseminate, employees are going to be notified that the provision of any false information can subject them to criminal penalties. Employers technically can be subject to those same penalties, but it seems far less likely if you're relying on the good faith of your employees to provide you with accurate records. Catherine, is it only teleworkers? I think this is related to the question I just answered. I think so. I'll send up my slides in a minute here, but I believe the exact language used in the regulation is an authorized teleworker. Otherwise, if the employee is going to get a COVID test from Convenient MD, for example, well, that test is going to be administered by somebody right there on site, and so that's coming from an authorized healthcare provider. What OSHA is referring to is someone taking a at-home test that either has to be monitored, by a teleworker, over some Zoom conference, or it has to be monitored by the employer. Does the NH lawsuit against the mandate protect us from having to implement this? I don't know what implement this is. The NH lawsuit that I was referring to concerns the CMS requirement for healthcare industry employees. And so that is not effective in New Hampshire right now. I believe New Hampshire has also joined the lawsuits with respect to the ETS, but that is ultimately going to be decided by the Supreme Court next week. Probably oral arguments are going to occur this week.
Hey, Brian,
so there we go.
Brian, quick question for you.
Sure.
And I think it relates to Larry Haynes's question. My understanding, based on what you said, is that regardless of what happens with the Supreme Court decision, we have to be compliant with this by January 10th, or we could be subject to fines from OSHA. Is that a fair statement?
Nailed it.
Okay, so, and what happens if probably getting off base here, but what happens if OSHA decides to fine a company January 10th or beyond, and then later the Supreme Court says, no, we're going to strike this down? Does that mean that the fines go away?
Yeah, well, I mean, if I think the fines under the ETS are $13,000 per violation. And if OSHA fines somebody on, let's say, January 12th, and on January 15th, the Supreme Court strikes down the ETS in its entirety, well, then there's no basis for OSHA's fine. And OSHA was not able to fine you in that capacity. Keep in mind, however, that every employer still has a general duty to provide a safe working place for its employees. And so if the employer has not gone through OSHA's just guidance and determined really what guidance it's going to implement and what guidance it's not going to implement, OSHA could still fine you under that.
Well, this is really some fantastic information, Brian. This is very scary for large employers, as I'm sure many people on this call are recognizing right now. But that was terrific information. And just remind folks that are on this call that this has been recorded. It's going to be available on the Chamber website if you want to review it, or there are others that you think should take a look at it. So it's there with a bunch of other great videos that deal with topics like this. I just want to thank Sheehan, Phinney, Bass and Green, Brian Bouchard. Fantastic presentation. That was so informative. I really appreciate it.
Thank you so much for having me, and Happy New Year.
Happy New Year to you all. And thank you, Kelly. Have a great day, everybody, and we'll be in touch.